Good afternoon, everyone. We are the Group 4 and we are going to discuss the Title 2 of Book 3, Conditions of Employment. Chapter 1, Preliminary Matters. Article 97, Definition of Wage, Salary, Facilities, and Supplements. Wages are payments made to workers for their services at an hourly or daily rate. Halimbawa dito ay ang mga blue-collar jobs. Salary refers to the annual payment made between the agreement of the employee and employer. The example of salary earners are the white-collar jobs and etc. Facilities refers to the expenses made by the employer to his employees. It can be deducted on the wage depending on the agreement between them. Examples of facilities that the employees can acquire are board and lodging. Lodging is a temporary in nature and refers to a short stay at a guest house or hotel, while boarding implies staying at a place for a long period of time. Supplements refers to benefits given by the employees to his or her employees beyond their earnings, such as pay for vacation, paid sick leave, maternity leave, pension, retirement, and death benefits.
Article 99. Daily paid versus monthly paid. A worker is daily paid if he gets paid only for days he actually works. A worker is monthly paid if his monthly rate covers all the days of the month. Ang daily paid ay sahod na binabayad sa mga empleyadong arawan ng sweldo o ang tinatawag na daily paid employees. Ang pagbabayad ng daily paid sa mga empleyado ay based sa mga araw na sila ay nagtrabaho at sa mga araw ng regular holidays na kahit hindi sila pumapasok. Ang monthly paid naman ay sahod na binabayad sa mga empleyadong buwanan ang sweldo o tinatawag na monthly paid employees. Ang pagbabayad naman ng monthly paid sa mga empleyado ay araw-araw sa bawat buwan, kabilang dito ang mga araw ng unworked rest days, special days, and regular holidays.
Article 100. Prohibition against elimination or diminution of benefits. Nothing in this book shall be eliminate or in any way diminish supplements or other employee benefits being enjoyed at the time of promulgation of this code.
So, sinasabi po dito sa Article 100 na bawal daw pong bawasan o tanggalin yung mga existing benefit na tinatanggap ng empleyado nung time na inilabas tong batas na ito. So, andito din po pumasok ang bonus at 13-month pay. So, ang bonus ay yung hindi inaasahang karagdagang benepisyo dahil sa pagka-loyal mo sa iyong pinagtatrabahuan. At ang 13-month pay naman ay isang benefits na nakukuha ng empleyado na matumbas ng isang buwan nilang sahod at makukuha lamang ito para isang buong taon ka nang maninilihan sa kanilang kumpanya.
Article 101, Payment by Results. Tinutukoy dito na dapat mapangisiwaan ng Secretary of Labor and Employment ang pagpapatupad ng panuntunan sa pagbibigay ng sahod base sa resulta ng gawa. Halimbawa dito ay ang mga trabahong pakyawan. Sa pamamagitan nito ay masisiguro na pantay at makatwiran ang rate ng sahod na ibinibigay para sa mga manggagawa.
Article 102. Forms of Payment. No employer shall pay the wages of an employee by means of promissory notes, vouchers, coupons, tokens, tickets, cheats, or any object other than the legal tender, even when expressly requested by employee. Sinasabi dito na ang sweldo is hindi pwede promissory note, hindi pwede vouchers, hindi pwede coupons, tokens, tickets, cheats, or any object other than money. So, ang sweldo natin sa empleyado is money, not in the form of rice or other object. Because I observed so many provinces, merong mga employer na yung sweldo nila ay in the form of rice, groceries, and that is unlawful according to this article. So, kailangan employer, business owner, and employee, dapat aware kayo dito. Dapat ang sweldo ninyo cash, hindi object, hindi promissory note. Article 103. Time of Payment. Wages shall be paid at least once every 2 weeks or twice a month at intervals not exceeding 16 days. Sinasabi sa article na ito ay yung payment sa service na nagawa ng mga empleyado na dapat on time, madidelay lamang ito at valid lamang ang pagka-delay niya at ito ang tinatawag na force majeure. It means may times na parang out of control ng mga company yung cost ng pag-delay ng pagpapasahod sa mga empleyado at kailangan nilang magpasahod within the time frame na ibibigay nila sa mga empleyado nila.
Article 104, Place of Payment. Payment of wages shall be made at or near the place of undertaking except as otherwise provided such regulation as the Secretary of Labor may prescribe under condition to ensure greater protection of wages. Sinasabi sa article na daw na pwede sa office or sa bank account ng employee mo ilagay ang payment of wages.
Article 105. Direct payment of wages. Wages shall be paid directly to the workers to whom they are due except Letter A. Kapag may paresahang insidente at imposible na maibigay ang sahod, ilalapit ito sa Labor and Employment at kapag naipasa, ay maibibigay ang pera sa pamamagitan ng ibang tao or yung may otoridad na binigyan ng naturang empleyado. Or letter B, kapag ang empleyado ay namatay, ang pera naman ay mapupunta sa tagapagmana nang hindi na kinakailangan na dumaan pa sa isang proseso.
Article 106, Job Contracting and Labor-Only Contracting.
Job contracting and labor-only contracting differs. By the way, this is an older PowerPoint. This used to be regulated by Department Order 174, but presently, Department Order 174 have been thrown out by the current administration, but it was replaced by another department order. But this department order, it did not entirely remove the prohibition on labor contracting or job contracting. Job contracting remains and still is a legitimate and a valid practice, but only that there are some safety nets that have been employed. But before we further move on, it is important that we understand when it's legal, when it's not legal. Now, take note that whether you're engaged in a legitimate job contracting or an illegitimate job contracting, there will always be that solidary liability, meaning both the principal and the agency or contractors are liable for all wages of the workers. No, although if it's legal, indirect employer lang ang principal as to the unpaid wages. So we go first to what is legal. And what is legal is what we call as a legitimate job contracting or simply job contracting. Now, the law, you have to base the determination of whether it's legal or it's not legal based on the law or the labor code. Now, what's the labor code say? Now, there is job contracting if the following conditions are present. So, ito yung, this is the one that is legal. The contractor carries on an independent business and undertakes the contract work on his own account under his own responsibility according to his own manner and method, free from the control and direction of his employer or principal in all matters connected with the performance of the work, except as to the result. So the first requirement is there should be no control on the part of the principal. Control as to the manner and means as to how the work is to be done. The control, if at all, should only be as to the result. Kumbaga, the principal will say, oh, this should be the result. But as to how you do it under your own supervision, however you want to do it. So if the employers will designate the time of work, the hours, will monitor or will even issue memo to the workers, that is control. And once there is control, remember, we go back to the definition of employer-employee relationship. And if control test is present, there's no contest anymore. The employee, even though how beautifully worded the engagement with the contractor is, for all intents and purposes, the employee is an employee of the principal. So take note of that. So there should be no control as to the means and methods as to how the work is to be done. Second, the contractor has substantial capital or investment in the form of tools, equipment, machineries, work premises, and other materials which are necessary in the conduct of his business. Now, this is interesting because if you look at the provision under the labor code, it speaks of capital, substantial capital or investment in the form of tools, equipment, machineries, work premises, and other materials. Now, if you look at it closely, it would seem that the contractor must have the facility. But then if you look at the provision more intently, it speaks of substantial capital or investment. So either or. That's why in the new circular issued by the Department of Labor, it speaks of a certain amount, no, millions of capitalization required. I think about 3 million. The contractor must have that certain capitalization to be able to qualify. Kasi meron na ngayon, there's now a registry of registered subcontractors. So at the very least, in the implementing rules, aside from this requirement, these two requirement, registration is now a requirement. And in registering it, you have to show that you have capital. So kung yung iyong investment, or rather kung yung contractor, supposed contractor, wala namang machineries, tools, and even worse, walang capitalization, then for all intents and purposes, hindi ito qualified as a labor contractor. Now, there are many cases that have been decided by the Supreme Court. There is this case in Coca-Cola, but in Philippines, where the Supreme Court noted that the engagement is not a legitimate labor contracting because it was Coca-Cola who established the supposed in-house company that's supposed to address another function of this, yung sa mga bote. So sabi ng Supreme Court, hindi. For all intents and purposes, the employees are deemed employees of Coca-Cola. So there are some cases to that effect where the court found that the engagement is not a valid job contracting. Now, which brings us to the next item. So that if none of these two requirements is present, then that is what we call as labor-only contracting. Now here, at the onset, labor-only contracting. Kaya sinabing labor-only contracting, ang kinontract mo lang yung labor. And if that is the case, that cannot be done because you cannot contract just the labor in these types of engagements. If that would be allowed, na labor lang i-contract mo, pero empleyado mo sila in essence, then you somehow go around the law, and that is not allowed. What cannot be done directly cannot be done indirectly. So what are the circumstances where there is labor-only contract? Number one, the person who's supposed to contract the service, or the agency, so to speak, does not have substantial capital or investment in the form of tools, equipment, machineries, work premises, and other materials. So kung wala yon, and this is a requirement of job contracting, outrightly you're labor-only contracting. Now, secondly, if the workers recruited or placed by such persons are performing activities which are directly related to the principal business or operations of the employer, which workers are habitually employed. So, ibig sabihin, if the work is directly related, so for instance, a university, a school, can a school engage the services of a subcontractor who will provide teachers for it? Definitely it cannot. Why? Because the work of a teacher is an integral part of a university, of a school, so it cannot be subcontracted. Another instance would be these food chains, which outrightly they really violate the rules. They engage the services of crew members who are supposed to be engaged by agencies, and then the agency will assign them to the food joints. Outrightly, this is illegal. Why? Because you cannot subcontract the work of crew members, no? Because that's direct part of the business of the restaurant. Unless what you are subcontracting is the entire business, no? Like for instance, in the case of Ayala Alabang Club, they engage the services of a restaurant to take over the entire restaurant. So that's different because it's the management of the restaurant that was taken over. So it is not on a piecemeal basis. But if it's on a piecemeal basis, and it would appear that you have workers that are hired by the restaurant and workers that are hired by the agency, that creates confusion and discrimination. So clearly that shouldn't be allowed. Now, aside from that, take note, no, labor contracting is prohibited, and the person acting as contractor shall be considered merely as an agent or intermediary of the employer who shall be responsible to the workers in the same manner and extent as the latter were directly employed by him. Sabihin, may solidary liability yung tao na yung agency is directly liable as if this is only an agent of the company. So the consequences therefore is that the employees recruited by the agency are deemed employees of the principal. Now take note that the Secretary of Labor can issue orders whether or not contracting out of labor is permissible in the light of the circumstances of each case. So the Department of Labor can prescribe conditions and restrictions to ensure protection and welfare of the workers. So dito na papasok yung iba't ibang circular. Ang daming mga circular on this na abuse and disabuse eventually. So presently, the Duterte administration came up with a ruling, but it's still, as I said, it's still why? Because the law allows it. Now, can there be a legislation that should prevent this practice? Well, yung subcontracting kasi is a universal practice. As long as it is above board, there's really nothing wrong with that. For example, you're a school and you want to subcontract the services of maintaining the comfort rooms. You don't have to hire your janitors, no, to do it. You can hire a company who specializes in cleaning comfort rooms, and that is allowed. Why? Because that's not the specialty of the school. That is not directly related to the business of the school. So that is universally allowed. So in other words, dito papasok yung mga core functions. If it is not a core function of the company, it should be allowed. Nagkakatalo yung determination now which one would be core and which one is not. Now, just for purposes of emphasis, let me just allow me to highlight the effects of job contracting. Dun muna tayo sa job contracting. No? Now, this is where job contracting lies. No? Job contracting. And as we said, job contracting is legal. Now, in a job contracting, there is the contractor and there is the principal. Now, in a job contracting, the contractors or the contractor engages the services of its workers. Let's call them C1, C2, and C3. Now, these workers are then seconded to the principal. They are allowed to perform service within the workplace of the principal. When they do so, they do not lose their status. They remain as C1, C2, and C3. Only that they perform service within the premises of the principal. Now, this is legal. Why is it legal? Because the principal should not be precluded to subcontract certain types of works, as long as they are not related to the business, and as we said, there is substantial capital or tools and equipment on the part of the contractor. So this is perfectly legal. So what happens here is that, notwithstanding the transmission or the assignment of C1, C2, and C3 to P, they remain C1, C2, and C3. So whatever responsibilities that an employer will have over them, the contractor generally remain responsible for everything. And and there is no direct employer-employee relationship with the principal. So here, C1, C2, and C3 are not employees of the principal. So they cannot sue the principal with respect to other incidents of employer-employee relationship, except if there are unpaid wages, so to speak. With respect to sa kanilang itinrabaho kay P, then they can go after P for the unpaid wages. Why? Because under a job contracting arrangement, C and P are solidarily liable for unpaid wages. C is the direct employer, while P is the indirect employer with respect to labor standards that have not been paid. Okay? So take note of that. But that is insofar as job contracting is concerned. How about labor-only contracting? Labor-only contracting. At the onset, labor-only contracting is illegal. Now, why is it illegal? It's illegal because it undermines the right to secure tenure of the employees that are seconded to the principal. Now, in a labor-only contracting, you also have purportedly the contractor on one hand and the supposed principal on the other hand. Now, like any ordinary engagement, the contractor hires its supposed employees, and they are supposed to assign them to the principal. Now, this is where the trick lies. No? Under a labor-only contracting arrangement, it's actually just the labor that's being contracted. Therefore, for all intents and purposes, C1, C2, C3, when they are seconded to the principal, they actually lose their supposed personalities as employees of the contractor. But in law, they are actually the employees of the principal. So this is where the difference lies. Once you are engaged by a contractor under a scheme of labor-only contracting, which is illegal, then by law, you are actually employees of the principal. And what happens here? The supposed subcontracted employee can now file a complaint before the National Labor Relations Commission for the determination of employer-employee relationship. And unlike the jurisdiction of the Secretary of Labor, you can, if there's no finding by the Secretary of Labor, because the Secretary of Labor can also find this. If the Secretary of Labor finds out, your work is directly related, so the Secretary of Labor actually can order the employer to absorb the workers as its regular employees. Now, if it does not do so, then you can go to the NLRC, file a complaint for regularization, and claim that, you know, you are actually the employee of the principal. There are many cases where the supposed subcontracted employees have been working for 10 years or even more with the principal, unknowing that they are actually employees of the principal. Why? Because all those years, they've always been under the payroll of the contractor. But of course, the payroll alone is not enough. The payroll alone is just a preliminary indication, but what controls would be the control, so to speak. So if you are being paid by the contractor, but the one who exercises discipline over you, who manages your schedule, etc., is the principal, and even worse, if the contractor does not possess the necessary tools and equipment, then for all intents and purposes, you are by law an employee of the principal. And labor-only contracting, such as in this case, is illegal outrightly.
Article 107, Indirect Employer. The provisions of the immediately preceding article shall likewise apply to any person, partnership, association, or corporation which, not being an employer, contracts with an independent contractor for the performance of any work, task, job, or project. An indirect employer, as defined by Article 107, can only be held by solidarily liable with the independent contractor or subcontractor.
Article 108. Posting of band. An employer or indirect employer may require the contractor or subcontractor to furnish a band equal to the cost of labor under contract, on condition that the band will answer for the wages due the employee should the contractor or subcontractor, as the case may be, fail to pay the same. Band is the amount rendered by an employer to the contractor as equal to the cost of labor payment into workers such as salary or wages. But if the employer fails to issue a band, he is responsible for paying wages or whatever expenses the contractor may incur, which later subject for reimbursement.
Si Cecil ay ginawa daw co-maker sa loan ng kanyang kaopisina. Ang terms daw ng loan ay dapat na mabayaran nito sa loob ng 2 taon. Laking gulat daw ni Cecil nang malaman niya na hindi pala nagbabayad ng utang ang kanyang kaopisina at ngayon daw ay siya ang sinisingil ng buong utang ng kanilang kreditor. Maaari daw ba niyang singilin o maaari daw ba siyang singilin dahil sa utang ng iba gayong co-maker lamang siya? Ano daw ba ang solidary liability at bakit daw sinasaad sa sulat sa kanya ng creditor na siya ay solidarily liable? Cecil, tignan mo ulit ang kopya ng pinirmahan ninyong kasunduan upang makasiguro kung nakasaad nga ba sa kasulatan na ikaw ay magiging solidarily liable sa utang ng iyong co-maker. Ayon nga sa kaso ng Industrial Management International Development Corporation versus NLRC, GR number 101723 noong May 11, 2000. Kapag sinabing solidary o kaya ay joint at several obligation, ang bawat isang tao na co-maker sa utang ay maaaring singilin ng kabuuan ng inutang. Kapag ang kasunduan ng pautang ay nagsasaad na kayo ay maaaring maging joint and solidarily liable, kahit isa lamang sa inyo ay maaaring habulin ng creditor para sa kabuuan ng inyong utang.
Article 110, Worker Preference in case of bankruptcy. In the event of bankruptcy or liquidation of an employer's business, his workers shall enjoy first preference as regards their wages and other monetary claims, any provisions of law to the contrary notwithstanding. So it means it is clear from the wording of the law that the preferential right accorded to employees and workers under Article 110 may be invoked only during bankruptcy or judicial liquidation proceedings against the employer. The law is unequivocal and admits of no other construction. Respondents contend that the terms of bankruptcy or liquidation are broad enough to cover a situation where there is a cessation of the operation of the employer's business, as in the case at bar. However, this very same contention was struck down as unmeritorious in the case of Development Bank of the Philippines versus Honorable Labor Arbiter Ariel C. Santos, involving a group of RMC employees which sought to enforce its preference of credit Article 110 against DBP over certain RMC real properties.